Welcome to the ICAHN Institute for Board Education. I'm Pat Scow, Executive Director of the Illinois Critical Access Hospital Network. I'm pleased to bring to you a two-part series regarding physician contracting and the legal ramifications of that, and your role and responsibility as a board member. I hope you enjoy viewing this two-part series that will not only cover your responsibility as a board member, but will cover some of the legal things, but what you need to know in approving contracts and reviewing and working with physicians and their practitioners on an ongoing basis. When I say physicians, I'm also including advanced nurse practitioners, physician assistants, nurse midwives, and others that are involved at that level in a medical provider education role. My pleasure now is to introduce to you Katie Anderson, who's on counsel with Heyl Royster, Volker, and Allen. She's located in the Champaign office. Ms. Anderson brings a wealth of experience in health education and health law, and has done a lot of work with physician contract negotiation and has covered malpractice. She's also served as in-house legal counsel for a large hospital organization. So thank you, Katie, for joining us today.
Hi, my name is Katie Anderson, and I'm here today to discuss the topic of physician contracting. Before we get into the specifics of what I'd like to discuss today, I want to talk to you about why it's even important that we're talking about the subject of physician contracting. First, I would say that physician contracts are usually one of the largest expenses for a hospital. This is either through the form of salaries and wages, if the hospital employs a particular physician, or in the amount that a hospital may pay to a group that is providing physician services to your hospital. Second, it is an area that is largely scrutinized and regulated by the federal government. So it's very important that the hospital follow the rules and regulations that apply to physician contracts. And third is some of the challenges facing hospitals in this area, and that's namely recruiting physicians, retaining physicians, and also ensuring that your hospital has the necessary coverage to provide to your patients. It can be very challenging for hospitals in this area in particular to recruit physicians. Typically, you'll see that younger physicians coming out of medical school tend to gravitate toward the coasts or larger metropolitan areas. So it can be very challenging to get a young physician or any physician to come to the Midwest, or even in our case, the state of Illinois. So physician contracting is a very important topic, and that's why we're here to discuss it today. So during the course of my presentation, I'm going to discuss some specifics, but then I'm also going to discuss some overall trends that we're seeing in the area of physician contracting. So first, I'd like to talk about the types of contractual arrangements that a hospital can have with a physician. The first is your standard employment relationship. So this is a situation where the hospital employs a physician directly. And typically, this arrangement is reduced to writing, so there is an employment contract between the physician and the hospital. The second type of arrangement is what's called a professional services agreement, or a PSA. In this arrangement, your hospital contracts with another group, another hospital, or another clinic that employs physicians, and that group then provides physicians to your hospital to provide particular services. Professional service agreements are most often seen in areas like emergency department coverage, radiology services, anesthesiology services, and those types of services provided by a hospital. And lastly, we have something called Locum tenens agreements. Typically, these are arrangements that are shorter in duration and are used to fill a gap or provide coverage when one of your physicians might be on vacation or taking some kind of an extended leave. In the Locum tenens agreement, the hospital will contract with a company that essentially provides staffing services. So the locums company doesn't employ the physician directly, but they have agreements with physicians across the country who they then assign to a particular hospital to provide services for whatever the duration that is needed. Again, these arrangements are typically shorter in duration. So if you have a physician who is going to be out on vacation or out on leave, it might be more advantageous for you to utilize one of these more temporary agreements. I'd like to go back and discuss the employment relationship. So as I mentioned earlier, the employment relationship between a physician and your hospital will be reduced to writing. So in other words, there'll be a contract between the two parties. Some of the most common provisions and the most important provisions in an employment agreement are, first, the term of the agreement. So typically what you'll see in an employment agreement is one that is several years in duration. I would say typically most employment agreements are 3 to 5 years in length. And this is actually advantageous to both parties. So for the hospital's part, you now have an agreement with a physician where you are theoretically guaranteed the services of this physician for a certain number of years. From the physician's perspective, it also guarantees them employment for a particular number of years. And as we'll discuss later, it may even guarantee them a certain level of compensation during their employment term with the hospital. Another provision that's very important is the termination provisions. So in other words, how does each party terminate the agreement? I've seen situations where hospitals may want to limit a physician's right to terminate the agreement, and they like to do this for several reasons. Number one, we discussed the difficulties that a hospital may have in recruiting and retaining physicians, so a hospital may feel compelled to limit the situation in which a physician can terminate the agreement. So sometimes you will see hospitals limit a physician's ability to terminate the employment agreement to situations where the hospital has breached the employment agreement and therefore the physician is allowed to terminate the contract. However, what I recommend and what I see in other kinds of employment agreements is a situation where both parties are able to terminate the agreement by providing a certain amount of notice. So in this situation, I'll use the example of 6 months. As long as each party provides to the other 6 months' notice that they are going to terminate the agreement, they are allowed to terminate the agreement for whatever reason they choose. This allows, again, both parties some protection and some flexibility. From the hospital's perspective, you don't want to force a physician to continue working for your organization if they have become unhappy or if the relationship is no longer what it once was. From the physician's perspective, it gives them some assurance that if, as the parties continue in their employment relationship and something changes and that party is no longer happy, they can then end the contract and go work somewhere else. The notice provision provides protection to both parties. So from the hospital's perspective, the physician providing notice that they are going to terminate the agreement allows the hospital time to go and recruit another physician to fill that position. From the physician's perspective, if the hospital chooses to terminate the agreement, this then gives the physician an opportunity to seek employment elsewhere. While we're talking about terminating the agreement, another important provision that you will see in employment agreements is what's known as a non-compete clause, or sometimes called a restrictive covenant. This is a provision that prevents a physician from working for another party after their contract with the hospital has ended. Now, typically courts are reluctant at times to enforce these non-compete agreements, and that's because generally, as a matter of public policy, courts want to allow parties to work for whom they choose. However, as long as a non-compete agreement is reasonable in both scope and duration, it will be enforced. Now, when I say scope and duration, I mean that typically the way that non-compete clauses are drafted is that it prevents a physician from working in a particular geographic area for a particular period of time. So for example, 25 miles for a period of 2 years after their employment relationship with the hospital ends. Now, the geographic radius is designed to do exactly what the name implies, which is prevent someone from going to work for one of your competitors. And this is a legitimate business interest of the hospitals. You have spent time and considerable money, likely, recruiting this physician to come work for you. So you don't want that physician to then be able to terminate their agreement with you and go work for a competitor. Again, we talked about the fact that a non-compete agreement needs to be reasonable in both scope and duration. So for example, you cannot prevent a physician from working within 100 miles of your hospital for 5 years after your employment arrangement ends. But something that's more limited will likely be enforceable by a court. And these are very important provisions. Lastly, and perhaps most importantly, the compensation provision in the agreement is the most important part. So there are many different forms of compensation that are paid to physicians. First is the base salary paid to a physician, and this base salary is typically paid regardless of the amount the physician produces, and we'll talk about what produce means in a moment. There are also certain bonuses that can be paid to physicians under employment agreements. So you may see something like a productivity bonus. Now, a productivity bonus is based on something called a work relative value unit, or a WRVU. Now, the Centers for Medicare Services, or CMS, basically assigns a value to anything a physician does. So for example, if a physician has a standard office visit for a wellness exam for a patient, that particular service is assigned a work relative value unit, or a WRVU. And there's a value attached to that. So a productivity bonus is structured where, as long as a physician earns enough to support their base salary, anything that they produce in excess of their base salary gets paid to them as a bonus. There's also bonuses that are awarded for performance or quality metrics. So things like achieving a certain level of patient satisfaction or certain quality metrics. I'll use the example of if a physician attains, let's say, screening a particular percentage of patients above the age of 65 for osteoporosis, the hospital may decide to give a bonus for that because that sort of screening is very important to the health and wellness of the population it serves. There's also things like signing bonuses, retention bonuses, there can be loan forgiveness, and other compensation that is paid to the physician to make the overall package attractive. Now, it's important when we talk later about the regulations on physician contracts that when you are considering the amounts paid to a physician, you have to take into account all compensation paid to the physician. So this is not just the base salary. This would include the base salary, any bonuses awarded to the physician. If the physician has a medical director position, a medical director position is additional duties that are assigned to a physician in a particular area. So let's say, for example, that physician is going to be the medical director of radiology services. These are administrative duties and functions the physician is going to be performing in addition to their clinical duties, and they're compensated for that. But that compensation is taken into account when you are looking at the total amount of compensation paid to a physician. So we have just finished talking about the various types of contractual arrangements with physicians, namely the employment agreement, the professional services agreement, and the Locum Tenens agreement. In the next video, we'll be discussing the federal statutes that govern those contractual arrangements.